Hello, everyone. My name is Eileen Matter, and I'm with Manulife Securities Insurance Inc. And it is my absolute pleasure to return yet again to the Senior Showcase and present my workshop entitled "New Rules for Executors and Estates in Ontario." Now, a little bit of background on myself: I am a financial advisor, financial planner, and have been so for 33 years here, serving clients in the Peterborough and Kawarthas, originally from Toronto. And I have several specialties in my practice. Retirement income planning is one, and another larger one is estate planning. To that, I belong to a group called the Peterborough Estate Planning Council. And what we do is get together once a month. We're an interdisciplinary group. There's lawyers, accountants, financial advisors, financial planners, insurance people, and charitable people. We get together once a month and we just talk about the new rules and what's happening in the world of estate planning and how we can take that information and assist our clients to streamline the estate planning and the estate settlement process. So what I'm here to talk about again is some new rules that came into effect in Ontario as of January 1st, 2015. And that really impact estate settlement and executors' roles in Ontario. And what I'll do is I'll get into those rules, but before that, I'm going to spend a few moments, just some general comments about estate planning and on its own, and then I'll get into the new changes, how they impact estate settlement, and then lastly, I'll have some solutions, some tips on how you can simplify the estate for your family, and if you're an executor, what you can do to simplify things. Sounds good? So let's begin. What is estate planning? Well, it all begins here with families. We have, each of us over our lifetime, have worked hard. We've accumulated assets, and we've enjoyed those assets that we've accumulated in our working years into our retirement years. And then there's that time that comes that, okay, now I'm no longer, what do I want to happen with what's left over? Those assets, whether property or investments, who do I want it to go to, and how do I want it to go to them? And family is very central to that. There's a theme in my presentation today, and it's change. I talked about the new rules that are changing, but there's been a lot of changes that we've seen as practitioners in the 33 years in the family unit. Number one is where we're living. Gone are the days where you had mom and dad growing up in East City, and the family grew up in East City in Peterborough, and then the kids bought a house down the street, or maybe in the north end of Peterborough, or they did something close at hand. Now what we're finding is we're finding more sons and daughters that not only are not living in Peterborough with, let's say, the grandparents, but they could be living either out of province or even out of country. I'm a perfect example of that. I have two adult children. My son is in BC, so he's considered out of province. And my daughter has been living and working in the US in Massachusetts for the last 10 years. So I have one that's out of province and one that's non-resident. It doesn't mean that they're not going to get what I have left over into that estate, but because of where they are, there are certain tax complications and there are certain administrative complications because of where they're residing. So these are the things that we have to take into account when we're planning for estates with our clients. The second way that families have really changed is seeing more and more blended families. Sometimes it's between grandma and grandpa that have divorced. Sometimes it's amongst the adult children or even the grandchildren. Sometimes those breakups are amicable and other times they're not. The key point is that when I do the initial fact finding, or any practitioner with a client, there's the art and the science of estate planning. The science is the hard facts. What assets do you have and where are they and how much are they worth? But the soft facts are these family dynamics that we need to be aware of in order to simplify their estates as much as we can. Now, when you're planning an estate, there's tools that we use. And here's the slide that, again, there's wills, there's power of attorneys, trusts, gifts, and executors. So will, everyone knows what a will is. It's that document, that piece of paper that has your instructions. These are my assets, and this is my wishes of who and how do I want family members to receive it, or perhaps members of the charitable sector to receive it. So these are the things that are all documented on this will. It's an important document because this is the only way you get to express your wishes. And yet, surprisingly, the statistics are in Canada that less than 50%, it's between 46 and 51% of Canadians today have a valid will at the time of their death. And it just makes it very complicated. So one piece of advice I'd give at this point, please make sure your wills are current and up to date. You'll also be assigning powers of attorney. That's for property or personal care. You could be getting into trust arrangements for your family. There might be gifts that you want to give, early on to, again, charities or to family members. And the last key point is appointing an executor. And this is very important. So what is an executor? Well, again, I'm going to bring back my will here. They're like the administrative assistant. You're no longer here. They get this document and they have to carry out your wishes in terms of what you want to do. So appointing an executor, it's a very onerous task. And in fact, if I was giving this presentation as I have in the past in a group of people in an audience, I would ask the following two questions. I'd ask with a show of hands, how many of you have ever been asked or had the role of an executor? And then and then after the hands go up, I will ask, now tell me, that role as an executor, was it more than you thought it would be or a lot less and a lot easy? And as you can well imagine, the response that I get from the audience is as this: it's a lot of work. I mean, if you think about it, the role of the executor is they first have to gather all the assets that clients have. Where are all the bank accounts? Where are the investment accounts, the insurance policies, the property deeds, all these things that they have to do. Couple that with my original comment, and imagine if if an executor is living outside of, they have to take time off work to come into the city where mom and dad is. Let's use Peterborough as an example. And they have to take time to meet with all these individuals. It becomes a very onerous task. The second point I also want to make is when you do appoint an executor, they don't have to take that job. You're appointing them. It's your wish that they become the executor, but at the time when you pass away and that executor has to assume the role, they may not be able or capable of taking on those responsibilities at that given time because of things that are happening in their own life. They may have health issues or work issues, or are now living so farther away from the time that you originally appointed them. My simple tip right here again, please always appoint a secondary executor. So if one is unable to take on that role, you've appointed someone else that you trust to take on that responsibility, because without appointing a secondary executor, if the first executor says, sorry, you can't do this, then in fact, it will go to the courts and they have a formula that they will be settling your estate in. So when you're settling the estate, there's one thing, we have costs involved in settling an estate in Ontario. A lot of questions I get in seminars, do we have the estate taxes? There's a lot of rumors in the media about what's changing. And as of today, no, we do not have the types of estate taxes that people who own property in the US are very much aware of. But that's not to say that there aren't costs in terms when it comes to settling an estate in Ontario. And let me take you through this slide. So I'm using Ontario here as an example. And these are the costs associated with settling your estate. So there's 4 of them: probate, executor fees, legal fees, and accounting fees. So I'll quickly go through them one by one. So what is probate? So here is your will. Before you can start acting on these instructions that you've laid out on the will, either you or your lawyer, you have to get a probate stamp. And what is that? It's simply a process that validates the will. How it's done is your will ends up on the desk of a court judge. They review it to make sure it's all in order. They approve the appointment of the executor, and a stamp is applied to that form. And then you get it back, and then it goes back to the lawyer's office. There are, though, fees associated with getting a probate stamp applied to it. Right now in Ontario, it is 1.5% of anything over 50,000 in that estate. So the first thing you're going to be doing is doing a summary of, okay, what are all the assets in this estate? So the property, bank accounts, investment accounts, jewelry, that whole value of it, it's all added up, and it's 1.5% of 50,000. So if I use a simple example, say a $500,000 estate, then in that case, the probate fees alone would be close to $7,000 just getting that stamp applied. Then there are executor fees. An executor is legally entitled to get compensation from the estate for all the work that they're doing to settle this estate for you. Now, it varies by province. An executor doesn't have to take compensation, but most on average will take about 3% is the average in Ontario. Legal fees, depending on the complexity of the estate, will go from 0.5 to 3% of the estate. Accounting fees are generally done on an hourly basis, but if I translate all of this to a percentage basis and just go middle of the road and say the executor takes 3% and the legal fees are only 2% and the accounting fees are only 2%, well, on that $500,000 estate that I'm talking about, then you're going to have just under $40,000 of expenses before we've paid final expenses or taxes on that estate. So it's significant. But the other factor, not only is there cost involved in settling an estate in Ontario or any province, there's the time. That first step, remember where you had to get that stamp by the court judge? Here in Peterborough, prior to COVID, my colleagues here in the community, the lawyers were saying that we were fortunate that we were getting a probate stamp when a will went to a local judge. They were generally getting it back in as little as 4 weeks, and maybe 4 weeks up until about 12 weeks. If you're in a larger center like Toronto or Mississauga, a larger city, you could be looking at 3, 4, 5 months before even that first step is happening here, is applied, actually, that it gets returned so you can start settling in a state. My colleagues, when I've done this presentation in the past with other lawyers, each of them without fail has advised the audience that don't be surprised when you walk into an office, a lawyer's office, and there's been a death in the family and you have the will and you want to start the estate settlement process, that they're advised that be prepared for the executor's year. Starting now, it will be upwards. It wouldn't be unusual to be up to and even over a year, depending on the complexity of an estate, before you start being able to disperse some of the assets that are in that estate. So now the changes, that's why we're here. So talk about the changes. So let me give you some background to the changes that have been happening. So prior to 2015, do you remember how I talked about a moment earlier about getting probate stamps? So you take this will and you have to do an inventory of what's the total assets of that estate. So adding up the bank accounts, the cottages, everything like that. Prior to 2015, this was done on the honor system. The executor simply took a piece of paper like this, wrote down, tallied all the assets, came up with a total, 500, a million, 2 million, whatever the value of that estate. And that's the number that was used for the probate calculation, that I mentioned earlier. Our prior government at the time for years that was concerned that with this honor system in place, that perhaps some executors were either accidentally or deliberately omitting some assets out of this sheet or deliberately undervaluing some of the assets. And that was impacting directly the revenue that the province was getting from estate settlement. So that's why we have a new process. And it began January 1st, 2015. It's been in place for 7 years. So what are the new steps? Well, number one, simply gone is the honor system. You now have a new process for following probate. And it includes, so you file something called an estate information return that has to be submitted, as well as this probate sheet within 180 days of getting that probate stamp. So what is new? Two big things that are new. Remember, gone is the honor system. Now the executor has to detail and verify the value of each of the assets that have been listed on this sheet. So it's simple for bank accounts or investments because you can get the current statements. You might have to get market values if there's any properties or cottages that are involved. So all of this has to be detailed. You don't have to submit it. The estate information return is like a tax return. It's like when we file our taxes, you say this is what you've got in RSPs and other expenses. You don't have to submit it, but you have to hang on to them in case they're asked for. It's the same process with the estate information. You have to have a file verifying all the values of the estate assets at the time of death, and you don't have to submit it, but you could be asked for it. And the second key point is now that there's penalties and audits. So just like the tax system, they can come back, which is the attorney, the Attorney General's office here in Ontario, they can come back and question the estate information return. And if something has been selectively omitted, there's penalties that are applicable. So this is how estates have been settled now for going on 7 years now in Ontario. So what are we finding now in terms of having this new process in place? Well, it's another form. We have an estate information return that has to be completed. Usually the lawyers will do that for a small fee for the clients. But so a little bit more time, a little additional cost. But the big thing that's really coming up right now is there's certain estate planning strategies that we have used for years as practitioners that are no longer, what used to be black and white, you can do this, are no longer so. And what am I talking about? Joint ownership. And I'm going to just share here, before I get into, I have articles, information pieces for the Manulife Tax and Estate Department that I will make it available to anybody who's interested in any of these articles by emailing me while these seminars are being posted on the Senior Show, and I'll get copies to you. Joint ownership is, for years, has been the tried and true way of reducing how much of your estate has to go through probate and that whole process, and how much and how quickly assets can go to your named beneficiaries. So I want to make 2 points here. First off, when you are considering joint ownership, before we even talk about estates, as a practitioner here, as a estate practitioner, I want you to be cautious. And this cautious for several reasons, because when you have an asset, let's use a bank account as an example, and you want to add a son or daughter's name, somebody else's name to that bank account, there are several things that will happen. Number one is, first off, there's a taxable disposition. So if it's an investment account and it's been growing and you've never paid the taxes on it, it's as if you sold it and now you have new owners, it's yourself and someone else. So you'll have a tax bill to pay. There'll be a deemed disposition. There'll be a tax bill to be paid, especially when it comes to property like cottages. If you want to add somebody on as a name to avoid having to go through, pay the taxes at death, you'll be paying them a much sooner. The other thing you have to be aware of is the liability risk. When you add somebody else's name to one of your bank accounts or investment accounts, say a son or daughter, heaven forbid if that daughter goes through either a divorce or a bankruptcy, because her name is now on mom or dad's asset, it will be drawn into the family law and all the divisions that are required with that court action. And there's a loss of control. Because now if you have an investment account that was in your name alone, now you maybe have 2 or 3 different names on it. Sometimes if you need to make changes to it, it may require all signatures. And if everybody's not living close, it just becomes cumbersome and you're losing control of that asset. However, having said all that, when it comes to the estate, here's what we're learning. And this is as a result of the estate information return and the guidelines that accompany it. With joint ownership, use caution. I've covered the reasons why, because of risk, taxable, and it's always recommended between spouses to have accounts between spouses and joint names. But it is not recommended any further with non-spouse, so we're talking children, grandchildren, somebody else, for estate purposes. Having a small bank account, maybe with your joint with your mom or your dad, so you can pay their bills, that's absolutely appropriate. But when it comes to larger assets, it can't be done. It should not be done. And the reason for this is, again, this estate information return that I'm talking about. And there have been several court challenges, and I'm just going to read. I was going to try to do it without my readers. It won't happen. There was a recent court case just about a year ago now where this was challenged. A father had passed away. He had 2 sons. He named only one son as joint in one of his bank accounts. And then when he passed away, initially, the bank gave the money all to that one son that was named. But in fact, the son who was left out challenged it. And this is in a court case that was a year ago, Picori versus Picori. And the judge ruled as follows. When an adult child is named joint owner of a property, such as a bank account or an investment account, to which they have not contributed, it is presumed that the adult child is holding the property as trust for the parent's estate. So therefore, when they pass away, that joint asset is rolled into the estate and is subject to probate, so it hasn't bypassed everything. One last point. Something that a lot of people are not aware of is that when a will goes through a probate process, it becomes a public document. So what does this mean? It means you or I can go to any courthouse in Ontario, pay a small fee, and get a copy of somebody's probated will. Well, is that a big deal? And well, yes and no. And again, remember my earlier comments, it depends on the situations in that family or with that business. I have behind me in my filing cabinets two wills that I hold. One is for Harold Ballard. For those of us my generation and or we remember Harold Ballard, who passed away in Toronto in the 1990s, owned the Toronto Maple Leafs and a lot of buildings and sports franchises. And I also have a copy of a most recent will, Rob Ford's, who passed away, and I forget now, several years ago, 5 years ago, I believe now. So the point being, because it becomes a public document, anybody can take a look at that will. Let's use Harold Ballard's as an example and say, okay, this is what I'm getting, but what's everybody else getting in this estate? Those of us who remember the media in the 1990s in the Toronto papers, there was frequently stories about Harold Ballard's will being caught up in the court system because of his then live-in girlfriend, Yolanda. And again, if I'm before a group, everybody remembers the name. So quickly, what was that story? Yolanda, in part of Harold's estate, was given a lump sum and a monthly stipend to last her for the rest of her life. But when she saw what everybody else was getting, she said, not fair. I want a higher amount, lump sum, and I want a higher monthly stipend for the rest of her life. So she contested the will. When a will is being contested, then two things happen. All assets are frozen. Nobody else gets a single penny until that court case is settled. And then number two, whatever the settlement, all the legal fees are taken out of the proceeds of that estate as well. So it reduces the net value of the estate. And that's in fact what happened in Yolanda's case. Eventually, after several years in the Toronto court system, she was awarded a higher lump sum and a higher monthly stipend for the rest of her life. But in the meantime, nobody else had any access to their portion of Harold's estate. So you're probably wondering now, well, thank you, Eileen. I came for information and now I'm kind of discouraged because, okay, I have an estate and I want my monies to pass on to my children. And okay, yes, one is out of country and yes, there's been a divorce. And so privacy is a concern. What do I do with all of this? And so I'm going to share with you some solutions. And that's what I promised to do to finish the seminar here, is to show you some solutions that have been in place for a number of years. They're not new by any means, but allow practitioners and clients to bypass some of these new rules and to simplify things for clients to still, to still put in place the wishes that you have for your estate. So what am I talking about? Let me introduce it. So again, this has been around for years. I'm going to be talking in the investment channel. And for years now, Canadians and clients can purchase their investments from one of two different channels. You can buy them traditionally from the banks or the brokerage firms, or you can also buy them from insurance companies. Now, why is that distinct? So insurance companies, and this may be news to a lot of people, do have very strong investment wings. They offer investment funds that are exactly like mutual funds, balanced funds, equity funds, and all the, Fidelity, Manulife, all the common names, the popular, they all are available as segregated funds. And they also have GICs that you can get from an insurance company. So why is this even a distinction? Because we have to stand back. We have to go behind those different institutions and recognize that there are different rules and regulations that operate, that govern the banking and the investment industry, and another set of rules and regulations that govern the insurance industry and its investments. So there are different rules compare them. And part of the new rules that are in the insurance side is that these insurance investments have very unique features not available in the banking channels, and they include mandatory guarantees, again not mandated in the banking or the investment channel. And as a side name, they're also referred to, that group investments from insurance companies are often termed segregated funds. And the term segregated comes from the fact that by regulation, those insurance companies have to keep a reserve separate from the underlying investment, so that if they do go down, there is a downturn in the markets or whatever, they have the resources to bring that client to whole. So, what are some of these guarantees? Very briefly, I want you to consider it's like having a menu, and you have these different options on your menu what you can choose. You can have a maturity or a capital guarantee. The very minimum for all investments through insurance companies or segregated funds is 75% capital guarantee. So in other words, if the fund drops by 40% because of the markets, oh wait, they did that about a year ago, and someone passes away, then there is restitution. There are options available with some carriers that you can pay an extra fee and take that guarantee up to 100% if you like. There's death benefit guarantees. Some of the older ones used to escalate the estate benefit guarantee. Another area that I specialized in for years, was income for life guarantees. We have fewer pension plans. If people don't have pension plans, what this allows individuals to do is take their individual RSPs or their RIFs and turn them into guaranteed income for life plans. And that's unique. But no matter which one, let's just stand back here, no matter which option you're selecting on a segregated fund, and this is what you do on the application, the one feature that all segregated have funds, even the most basic vanilla segregated funds have, is the following feature. And that is the ability to name beneficiaries directly. So this is not joint ownership. You're naming a beneficiary directly on that asset. We can do that now at the banks on our RSPs and our RIFs, but we can't do it on any cash investments. Like you sold your home, for example, and moved into one of our retirement residences here in Peterborough. That money, you cannot name beneficiaries at the banks, but when you have insurance from investments companies, you can. So what does that mean? What's the benefit of that? A whole bunch. First off, we bypass probate, because any asset that has a named beneficiary, it's not included when it comes to the calculation of assets for the probate fees. It's also not included in that estate information return. That also has to now be completed. And the last thing, it's completely private. Whereas before, on a will is a public document, you'll see how things were spread out. When you access that, if you want for an individual, this is completely private. It's done just simply between the insurance company and the individual. So let me just, as I'm writing down the presentation, I'm going to give you two examples of how I've used this particular tool or this investment in my practice to simplify and meet some of the estate wishes that my clients have. So this is my first picture. This is my story is about my client, Mary. Her name is not Mary, and this is not her real picture, but her story is true. So I met Mary as a client about 10 years ago now. She had recently become a widow, and she was still living in her own home here in Peterborough. Mary has two adult children. She has a son, married, living here in Peterborough with two now older daughters, two daughters, grown-up daughters, and another daughter who's out in Vancouver, out in BC. And so Mary had stayed in her home for a number of years, and her son was truly a saint. I mean, he would cut his grass, come over and cut her grass. He would shovel her driveway in the winter, come over and take care of her driveway. He was really taking care of both homes, his own and his mom's home. But then, as Mary got worried about all the time her son was spending looking after both properties, and we had a few of those Peterborough winters a few years ago where we just couldn't get out. So she made the decision that a lot of retired Canadians eventually do. This says, okay, I'm done with the home. Let's move into one of these retirement homes that we have here. And this is what I imagine. This is why I've selected this picture. Imagine what Mary's life is like at one of our homes here, our luscious retirement homes here in Peterborough. It's carefree, and she's enjoying life. When Mary and I met, after she sold her home to move into a retirement place, her and I met to do the planning of what we were going to do from the proceeds of the home. And she brought this up. She goes, okay, my will is the same will that my husband and I had drafted, that whatever we have in the bank accounts, like she had her checking account and savings account and a few GICs at the bank, all that's at the bank, and anything I own will be split equally between my son and my daughter. But when it comes to the proceeds of the house, is there a way that I can get my son to get a little bit more of what the proceeds of the house is versus her daughter? And these were her reasons why. As I've described, her son and his family were very, a key part in her support while she continues to live here in Peterborough. Her daughter, on the other hand, she only heard from once, maybe twice a year, and only when she needed money. So she wanted her son to get more of the value of the house. So here's what I did. I took the value of that house and we opened up an account, and it was for a segregated fund. It was an investment through an insurance company. She's the owner of that account. It was about 400,000. She alone is the owner of that account. She alone gets the income coming from that account. In fact, it's going into her bank account. So it's paying her bills, her monthly rent to the retirement residence, and always make sure that glass never goes empty for her. So it's paying her bills. But then what we have on that contract is we have named two beneficiaries for what's left over, because it's not locked in any way. When that time comes, what's left over of this investment, her son will get 70% of what is left over, and her daughter will get 30% of what's left over. So not only is it private from the will, and she knew enough of the dynamics of her children that if she put those instructions in her public will, that her daughter would have contested that. And it would made for this way, it's very private. And not only is it private from the standpoint of Mary's eventual will, but it's private amongst the beneficiaries. No one knows. Each of them, respectively, the son and daughter, will receive a letter from the insurance company expressing condolences on the death of the passing of the mother, that they have been named for the recipient, that there's proceeds of an investment account that are coming, they've been named on beneficiary on, and please provide instructions on how to do that. That's how simple that is. So it was a simple tool that accomplished her wish and avoided all the other pitfalls that we had talked about earlier, like joint ownership and things like that. Another quick example, grandchildren. More and more these days when I'm meeting with clients, they say, you know what, my kids are grown up, my adult children are grown up, they have good jobs, good pensions, good savings. I'm not as worried about leaving money for them, but I would like to leave something for my grandchildren. So when it comes to so here's my picture of 5 grown grandchildren on a dock here in the Kawartha Lakes. They'll be different in terms of personality, they'll be different in terms of temperament, and they're also going to be different in terms of how they manage money. And grandma and grandpa will know this. After years and years of giving them checks for their birthdays or education milestones, they know that, for example, the 3 on the left are excellent stewards of their money and good savers and prudent spenders. The 2 on the right love them just the same, but they're spenders. So yes, they could gift them some money and it would go in their bank account today, but it'll be the new iPhone or something else within a week or so. They're just spenders. So when presented with this planning wish from a client, a lawyer would set up a trust, and that's what they would do to do this. And they would set up a trust with these specific instructions. This is the amount, who's going to get a lump sum, and how the other, would have to, how the others, in what increments they could get that portion of their grandparents' estate. But there are costs involved in setting up a trust and maintaining it. The alternative in the insurance world is it's a form. It's called a settlement option. And it's a annuity settlement option. So it's one form that all I do for clients when in any, and I've had several of these, I will list the 5 grandchildren, and then on the other side we'll say, okay, they're getting a lump sum. The 3, the good money stewards will get their lump sum 20% immediately, and the other 2, well, they're going to get it paid out to them over 3 years or 5 years. And it's just a simple form, no additional costs, signed, witnessed by the client, by the advisor, and it goes along with that investment contract. And the beauty of this is simplicity, not only in setting this up, if you wish to control how the gifting of your assets happens, but it's also simple to change, because there's nothing like real life to teach the spenders when they have to go out there and have to start paying a lot more bills than they normally have, that maybe I need to hang on to things. So as you see that their money habits have changed in any way, you don't have any more concerns about how they will handle it, then you simply redo this form, and again, it's just on file. So it's a simple way of putting all these, it's a simple way of this is, again, a wish of a client, and you can use a unique application of investments from insurance companies. So in summary, as I wrap this up, change is the theme. Life is changing. I say this in the year of COVID mockingly. Yes, with lots of changes that we've all seen. But when it comes to estate planning, families are constantly changing where they're living, the dynamics of the family. And we also have change in terms of a new process, new responsibilities for the executor, and new liabilities with the new estate information return that's all there. So I'll leave you just with a suggestion, or simply not a suggestion, but just to advise that this is a tool that I use under these circumstances to assist my clients, is to consider the benefits of using investments from insurance companies or segregated funds to part of your portfolio. And the same applies to both mutual fund-like investments and or GICs. So the key features, again, just to summarize, of the benefits of investments from insurance company. Number one is speed of payment. Recall I mentioned that in a traditional estate setting, it could be upwards of a year of those assets that have to go through probate and the normal estate settlement process before they're actually reaching the hands of the beneficiaries. When it comes to insurance investments, two things that I require: I will need a copy of the death certificate from that individual, and then just a claim form that is filled out by the beneficiary that includes information, and usually it's banking information as to where they would like their proceeds to be deposited. Time for payment on that, remember, a traditional estate is almost a year, if not more. On the beneficiary designations, once the paperwork, that death certificate in this form is in head office in good order, they're paid within 10 to 20 banking days. And my personal experience is they're usually paid in it's less than 10. It's usually within 7 banking days. There are certainly cost savings when you're dealing with, because the portion of the estate that is going through these investments, that's avoiding probate, then you don't have the probate costs and other costs associated. You still have the opportunity, my example with both Mary and the grandchildren, that you can keep control of your gifts and how much are going to different beneficiaries. Much, much simpler, especially when you have beneficiaries that are out of province or non-resident beneficiaries. Just a quick example, a non-resident beneficiary, if they're receiving monies from a RIF or a registered asset, there's withholding tax here in Canada, but there's an additional 25% that a non-resident will be deducted when a non-resident is a beneficiary of those proceeds. Yes, then that resident can go and seek an accountant in the US or Europe, wherever they're living, and because if Canada has a tax treaty with that country, they eventually can get that money back that they've had to pay. But it's time, effort, and process. In contrast, and again, the reason why, it goes back to the rules and regulations that are different in the insurance industry versus the investment industry. When you have a beneficiary that's either out of province or non-resident of either a registered or non-registered beneficiary, they simply get the full amount. And there's no withholding, no additional withholding. And the last point is complete privacy. No one knows how your wishes have been what your wishes are for your estate. So all insurance companies will offer these investments: Manulife, Sun Life, Canada Life. I myself work with all the different practitioners. Manulife Securities is my dealership, and I work with all these insurance companies. And it's nice to have those options because there's a wide range of slight differences between the different carriers in terms of age limits and the options that they have available. But the key thing is that these types of investments can only be purchased from an advisor who is insurance licensed. And as of the current rules and regulations, these are not simply available through the banks. So I thank you for your time. I hope this information has been of value to you. And as a follow-up, Tiffany, before I hand this over back to you, I recall I talked about different information pieces that I will make available. My email will be available and my contact information so that if you're interested in these documents, there's one on being careful with joint ownership, the estate information return, any of those, simply, contact me directly and I will have those emailed to you at your convenience. So again, it's been a pleasure. I do look forward to when we can come back in person again and have our senior showcase. But I hope the my presentation has been of value. Fire off any questions you have and let me know if you'd like any copies of these handouts. My pleasure, and thank you, and have a great day.